Buenos días y bienvenidos a la 17ª versión de nuestro seminario Día de la Competencia, organizado por la Fiscalía Nacional Económica y que en esta ocasión hemos titulado Delación compensada y criminalización, una mirada desde derecho norteamericano, que contará con la participación de los expertos estadounidenses Richard Powers, quien es el subasistente del fiscal general de la persecución criminal de la División de Competencia del Departamento de Justicia de Estados Unidos, y Scott Hammond, socio de Gibson, Dunn and Crutcher. Saludamos y agradecemos a las autoridades que nos acompañan hoy. El presidente y ministro del Tribunal de Defensa de la Libre Competencia, los jefes de servicio, autoridades del Ministerio Público, autoridades del Ministerio de Economía, representantes de Carabineros de Chile y de la Policía de Investigaciones de Chile, y por supuesto a nuestros expositores extranjeros. También a todas las autoridades latinoamericanas que hoy nos están acompañando y por supuesto a todos los que hoy día están presentes con nosotros. Para comenzar este seminario, dejo con ustedes al Fiscal Nacional Económico, señor Ricardo Riesco. Ricardo, por favor.
Muchas gracias, Mónica, y muy buenos días a todos a quienes asisten el día de hoy de manera virtual, tanto de Chile como del extranjero. Es un verdadero gusto para mí y para la institución que tengo el privilegio de dirigir, recibirlos en esta 17ª versión de nuestro Día de la Competencia. Déjenme partir por confesarles que dudamos largamente si realizar o no este evento. Como ustedes bien saben, han bajado las barreras a la entrada para organizar seminarios y, como es natural, la oferta se ha disparado. Supongo que ustedes, como yo, han asistido este año a más seminarios que nunca antes y muy probablemente quizás a mucho más de los aconsejables. Pero finalmente decidimos hacer el Día de la Competencia por dos razones fundamentales. En primer lugar, porque es una tradición valiosa de la comunidad de libre competencia chilena. Desde hace ya casi 2 décadas, ha provisto una ocasión para encontrarnos y discutir la acelerada evolución que ha tenido nuestro sistema de libre competencia, cuyo buen funcionamiento es esencial para legitimar y obtener todos los beneficios propios de una economía de mercado como es la chilena. El año pasado ya debimos suspender este evento debido a la contingencia nacional por todos conocida, pero este año nos pareció importante volver a reunirnos, aunque fuese de manera virtual. Y en segundo lugar, porque creímos que era importante aprovechar la ocasión para tratar un tema de la máxima importancia que por diversas razones ha sido muy poco tratado públicamente: los desafíos que la criminalización de la colusión supone para la delación compensada. Porque la criminalización de la colusión, sumada a los cambios en el tipo normativo y al aumento de las sanciones administrativas que introdujo la reforma legal de agosto del año 2016, abrió un espacio muy significativo para repensar materias y para cambiar actitudes, tanto de los agentes económicos como de las autoridades, que debieran tener como efecto incrementar exponencialmente la moderada relevancia que, hay que reconocerlo de una buena vez, ha tenido la delación compensada en Chile hasta la fecha. Parece innecesario repetirlo frente a una audiencia como esta, pero nunca está de más recordar que, tal como se ha sostenido en forma reiterada nuestra jurisprudencia, la colusión es el más grave de los atentados contra la libre competencia, por el inconmensurable daño que causan a los consumidores, a la economía y a la confianza de la sociedad en el mercado, tal como demostraron los eventos acaecidos luego del estallido social de octubre del año 2019. La persecución de los carteles ha sido, es y seguirá siendo una prioridad para la Fiscalía. De hecho, es importante destacar que solo este año que ya termina, y con los topes de multa antiguos, la Fiscalía obtuvo sentencias favorables en casos de colusión que impusieron multas a beneficio fiscal por más de 100 millones de dólares, prácticamente lo mismo que en los 10 años anteriores sumados. Aunque también pueda parecer innecesario repetirlo frente a una audiencia como esta, es conveniente que no olvidemos nunca que a nivel comparado, la delación compensada es, por lejos, nos guste o no, el mecanismo más efectivo para la detección, persecución y sanción de carteles. Según las cifras disponibles, más del 75% de los casos de colusión de las dos principales jurisdicciones del mundo involucraron delaciones compensadas. También es bueno recordar de vez en cuando estas cifras porque con ellas se desvirtúan algunas creencias algo provincianas, con todo respeto, y bastante peregrinas, que a veces se emiten por la opinión pública. Primero, aquellas que aseveran que las colusiones solo se producen en Chile o que en nuestro país existe una mayor proporción de colusiones que en otras jurisdicciones. Y segundo, aquellas que afirman que la delación compensada es un invento chilensis para garantizar impunidad a quienes se coluden. Nada más equivocado, porque es justamente todo lo contrario. Ciertamente, nos falta recorrer un buen camino de promoción de la competencia, de advocacy, para que en Chile se acepte que la delación compensada es por lejos el principal mecanismo que existe en todo el mundo para detectar, perseguir y sancionar a quienes se coluden. En otras palabras, la delación compensada es esencial para evitar que exista impunidad para quienes se cartelizan. Tal como señalé anteriormente, en Chile, desde su introducción en el año 2009, hace más de una década, la delación compensada tenía una relevancia que, podríamos decir, ha sido moderada. De los más de 20 requerimientos por colusión presentados por la Fiscalía desde el año 2010, solo un tercio ha contado con delación compensada. En menos de la mitad de esos casos, las delaciones compensadas llegaron antes de que la Fiscalía ya hubiese iniciado una investigación por colusión. Estas son las delaciones compensadas por antonomasia, porque se refieren a carteles que la Fiscalía quizás nunca habría detectado sin la disposición a colaborar de las empresas y de sus asesores. En los demás casos, las delaciones compensadas se realizaron cuando la Fiscalía ya estaba investigando por colusión. De entre estos casos, en más de la mitad de ellos, la Fiscalía ya había ejercido facultades o medidas intrusivas. Estas cifras muestran, por un lado, que la Fiscalía no depende de la delación compensada para detectar y perseguir carteles en forma exitosa. Esto es una muy buena noticia, por cierto, pues sin el temor a ser efectivamente detectado por la autoridad de competencia, no hay incentivo alguno para delatarse. Y es por eso justamente que la Fiscalía trabaja dura e intensamente todos los días del año para aumentar su capacidad de detectar las colusiones de oficio. A eso obedece la reciente creación de la Unidad de Inteligencia, que está desarrollando herramientas de ciencia de datos para reforzar aún más nuestra capacidad de detección, así como para robustecer nuestra capacidad de preparar y realizar medidas intrusivas. Créanme cuando les digo que al día de hoy, la Fiscalía está en mejores condiciones que nunca para detectar carteles de oficio. Sin embargo, las cifras antes señaladas también muestran que hay un gran espacio para profundizar el uso de la delación compensada en Chile. Se han dado diversas explicaciones posibles a por qué la delación compensada ha tenido una relevancia moderada en nuestro país. Una explicación es que el éxito de la delación compensada podría haberse disminuido en economías pequeñas, en que los círculos de negocios son más estrechos y, por tanto, delatarse podría generar un efecto reputacional más severo que en economías más grandes. Otra explicación, relacionada pero distinta, es que, tal como ya explicamos, la delación compensada parecería no tener una buena acogida en la población general, por lo que la opinión pública no siempre le reconocería al delator que, a pesar de la ilicitud inicial de su actuar, ha recapacitado decidiendo hacer lo correcto y reportarlo a las autoridades. Asimismo, y según se ha dicho principalmente en discusiones internacionales, otra explicación es que el delator queda expuesto, antes que el resto de sus competidores coludidos, a indemnizaciones de perjuicios multimillonarias y o multijurisdiccionales. Otra explicación más es que la incertidumbre en los resultados del proceso sería un desincentivo de delatarse, lo que ocurriría en Chile porque son múltiples las autoridades que intervienen en el proceso de delación compensada. Si bien la multiplicidad de autoridades intervinientes es un hecho indesmentible en nuestro país, pues está en la ley y es parte de nuestro diseño institucional, hay algunas cosas importantes que no deben olvidarse. Por un lado, la Fiscalía nunca, ni una sola vez, ha rechazado una delación compensada que ha recibido antes de iniciar una investigación. Todas, cada una de ellas han sido aceptadas. Por su parte, la Fiscalía nunca ha revocado un beneficio ya otorgado a un delator, ni una sola vez, jamás. Y ustedes saben también como yo que por buenas o malas razones esto no ha sido así en todas las jurisdicciones del mundo. Y también hay que recordar que la Fiscalía tiene un historial consistente y exitoso, por todos conocido, de defender al delator, incluyendo el acceso a su información confidencial en todas las sedes en que ello sea necesario. El compromiso de la Fiscalía, en el que hemos trabajado y seguiremos trabajando, porque entendemos la extrema importancia de la evaluación compensada en la política de detección, persecución y sanción de carteles en Chile, es que el delator quede siempre en una mejor posición luego de acudir a la Fiscalía. Por último, otra explicación respecto a la moderada relevancia de la evaluación compensada en Chile es que habría escepticismo sobre si la Fiscalía dará real y efectiva aplicación a la reforma legal del año 2016. Quien así lo crea está total y absolutamente equivocado y tendrá un despertar muy, pero muy desagradable. La aplicación de reformas legales en asuntos tan complejos como son la colusión toman su tiempo en todos los países del mundo. De hecho, la Fiscalía se encuentra a puertas de aplicar la reforma legal del año 2016 en lo que respecta a los carteles. Y cuando concurran los requisitos legales, tal como lo hemos dicho, buscaremos la aplicación de la ley con su máximo rigor, no solo en sede administrativa, sino que también en sede penal. Sea como sea, no cabe duda de que existen múltiples razones que podrían estar detrás de la, digamos, moderada relevancia que ha tenido la evaluación compensada en Chile hasta el momento. Pero existe un hecho que es indesmentible, como que la reforma legal del año 2016 cambió sustancialmente el panorama existente en nuestro país. Por eso mismo, los agentes económicos y también las autoridades debemos replantearnos algunos temas, detenernos en algunos desafíos y cambiar actitudes que nos debieran llevar a aumentar el uso de la evaluación compensada en nuestro país. En primer lugar, como ustedes bien saben, las sanciones posibles por colusión en nuestro país aumentaron severamente. Hoy, las empresas arriesgan a título de multa hasta el 30% de sus ventas durante todo el periodo por el que se haya extendido la colusión, o hasta 2 veces el beneficio que la colusión les haya reportado. Las multas solicitadas por la Fiscalía ya han aumentado en comparación con el pasado y ciertamente seguirán aumentando en forma exponencial, lo que no es de extrañar porque es una consecuencia natural y fue justamente ello lo buscado por la reforma legal del año 2016. Asimismo, los ejecutivos que hayan participado en un cartel arriesgan penas de cárcel de entre 3 años y 1 día y 10 años, con un mínimo de prisión efectiva de 1 año. Como Fiscalía, ya hemos intensificado nuestra relación y coordinación con el Ministerio Público, con quienes hemos tenido importantes acercamientos y estrechas instancias de colaboración. Porque cuando se presenten querellas y tenga la certeza que se van a presentar, iremos de la mano con el Ministerio Público para intentar obtener resultados tan exitosos como los que ya hemos obtenido en el proceso administrativo. De este aumento sustancial de las posibles sanciones, se desprende inequívocamente que las empresas, y con ello también sus asesores, deben preguntarse muy seriamente, con detalle, con detención, a qué se exponen en caso de no delatarse. Si deciden no hacerlo, pueden comprometer seriamente su patrimonio y su libertad o la de sus clientes. Es verdad que, como vimos, podría haber algunos desincentivos a la delación compensada. Es que lamentablemente el mundo ideal no existe, ni en Chile ni en ningún lugar del mundo. Pero no olviden nunca que su cliente no se ahorrará ni la exposición mediática, ni el daño reputacional, ni la multa, ni la indemnización de perjuicios, ni la cárcel, ni tampoco potenciales cambios regulatorios, si su competidor o los propios ejecutivos de la empresa o de su cliente, que temen perder su libertad, tocan antes que ustedes la puerta a la Fiscalía. O incluso si nadie la toca, porque la Fiscalía ya ha probado su capacidad para perseguir carteles de oficio, sin necesidad de un delator, lo que estamos reforzando y seguiremos reforzando aún más a futuro, como ya vimos. En segundo lugar, la criminalización someterá indefectiblemente a la delación compensada a a un test de fuerza al que no se ha expuesto hasta ahora. Y esto implica, o debiese implicar, cambios en el actuar tanto de los delatores como de sus asesores y también de la autoridad. Y al menos en lo que nosotros respecta como Fiscalía, ya estamos trabajando para adaptarnos y para tratar de hacer realidad desde hoy esos cambios. En ese sentido, como Fiscalía queremos esforzarnos para acoger al máximo posible a los delatores y brindar la mayor certeza posible respecto a los requisitos para acceder al beneficio de la delación compensada, con el objeto de garantizar que todos los demás partícipes de la colusión, con excepción del delator, sean sancionados con el máximo rigor que establece la ley. Por eso, anunciamos que hemos iniciado un proceso interno de revisión de todas nuestras políticas, lo que incluye, aunque no necesariamente se limitará a, un nuevo análisis de nuestra guía de delación compensada, de nuestro formulario de postulación y de los requisitos de la solicitud de beneficios. Específicamente, queremos tratar de acompañar lo más cerca posible a quien ha solicitado un marker y no ha hecho aún su solicitud de beneficio. Queremos poner a disposición de quien tiene un marker todo nuestro conocimiento y experiencia para que lleve adelante su investigación interna adecuada y oportuna. Queremos ofrecer a las partes la mayor guía y transparencia posible en este procedimiento, colaborar al máximo posible con el posible delator. Y concretamente, esperamos que ello se traduzca en que también haya claridad meridiana en que para obtener el beneficio de la delación compensada es necesario por ley que se aporten a la Fiscalía antecedentes que constituyen un aporte efectivo para obtener elementos de prueba, ya sea para fundar directamente un requerimiento propiamente tal ante el tribunal, o también para fundamentar una solicitud de medidas intrusivas ante el tribunal. Esto, naturalmente, aplica a quienes solicitan el beneficio de la delación compensada antes de que exista una investigación de la Fiscalía. Por ellos, como es evidente y natural, tenemos una especial predilección quizás como institución, porque son ellos, principalmente, los que garantizan la existencia de una política pública efectiva para la detección eficaz y oportuna, para la persecución eficaz y oportuna y para la sanción eficaz y oportuna de los carteles en Chile. A los delatores que se acercan a la Fiscalía una vez que ya hemos iniciado una investigación, por cierto que también le damos la mayor de las bienvenidas, pero siempre que aporten antecedentes adicionales a los que ya tiene la Fiscalía en su poder, no como una herramienta de free riding que disminuya su responsabilidad administrativa y o penal. Por otro lado, es habitual e incluso entendible que existan diferencias entre lo que reconoce el delator y lo que termina por detectar la Fiscalía durante el curso de su propia investigación. En parte, esto se debe, y lo entendemos, a que las empresas y sus asesores enfrentan dificultades en sus investigaciones internas. Los ejecutivos que han participado en una conducta ilícita son también reticentes a reconocer su error, así como también a colaborar para que dicho error sea acreditado y sancionado en un juicio que por su propia naturaleza es público. Asimismo, entendemos que las empresas y sus asesores quieren limitar al máximo su exposición al riesgo, tanto en la conducta misma que reconocen como en relación a eventuales ramificaciones internacionales o para efectos de eventuales acciones de indemnización de perjuicios. Hasta aquí, de hecho, nuestra jurisprudencia ha aceptado que existe algún espacio para diferencias entre el contenido de la solicitud de beneficios y los resultados de la investigación de la Fiscalía, porque se entiende por la autoridad que el delator cuenta capítulos de una historia de la Fiscalía a través de las diligencias que realiza en su investigación, accede a los demás o a otros capítulos de la historia que completan el círculo. Sin embargo, y esto es muy relevante, tras la reforma legal del año 2016, en que la persecución penal será llevada a cabo por otro organismo y en que decidirán tribunales no necesariamente familiarizados ni con asuntos de libre competencia ni con la delación compensada, aquellos aspectos adicionales no reconocidos por el delator y que puedan surgir durante la investigación de la Fiscalía podrían eventualmente dejar expuesto al delator a ser considerado responsable criminalmente por tales hechos. Esto sería sumamente indeseable porque la Fiscalía, más que a nadie, porque representa el interés general de la colectividad en el orden económico, le interesa que el delator quede tan protegido como sea posible y compromete desde ya todos sus esfuerzos para resguardarlo desde que golpea la puerta de la Fiscalía hasta que concluya la persecución penal de los demás partícipes en la colusión. Esto asegura la supervivencia de la delación como institución y, por tanto, una política pública adecuada para detectar, perseguir y sancionar a los carteles. Cumplir con este compromiso exigirá a la Fiscalía doblegar sus esfuerzos para suspender por un instante su naturaleza persecutora e inquisitiva, para acoger al delator, para acompañarlo y guiarlo durante su investigación interna, con el objeto de garantizar que todos los demás partícipes de la colusión sean sancionados con el máximo rigor que establece la ley. Asimismo, sabemos que requerirá de nosotros atender con la mayor receptividad posible las eventuales preocupaciones del delator por riesgos de exposición en otros ámbitos, buscando la forma de que el proceso de delación, cumpliendo por cierto con todo lo que exige la ley, no implique que quien se acoge al beneficio quede, nunca y bajo ningún respecto, en una posición desmejorada en relación a los no cooperadores, de manera de no afectar la delación compensada nuevamente como institución. Pero ciertamente también exigirá, y mucho, de las empresas y de sus asesores. Demandará de ellas un máximo de transparencia en el proceso de postulación. En el escenario abierto por la última modificación legal, reitero que no hay espacio para especular respecto de cuánta evidencia entregar para conseguir el beneficio, ni para adaptar o acomodar aspectos de la historia de la ley para proteger los intereses o para limitar la responsabilidad del cliente. El foco debe estar en la prueba que aporta el postulante y no en las declaraciones de hecho y de derecho que exigimos hoy en día a quien solicita la delación. La Fiscalía y quienes se delaten deben ser una especie de socios en la defensa de la institución de la delación compensada y, por consiguiente, de los beneficios del delator, con el objeto nuevamente de garantizar que todos los demás partícipes de la colusión sean sancionados con el máximo rigor que establece la ley. Pero en esta sociedad, como en todas, requiere de confianza mutua. Como muestra la experiencia comparada que ya veremos, la mejor forma que tendrá el delator de proteger sus propios intereses será actuar en forma transparente, desplegando el máximo de sus esfuerzos para entregar a la autoridad toda la información que tenga, o que de buena fe pueda conseguir, dejando luego con confianza que sea la autoridad la que fije los límites de la acción que ejerza posteriormente ante el tribunal. Este proceder minimiza las posibilidades de que durante el camino surjan nuevos aspectos o aristas, cuya cobertura por la delación pueda ser cuestionada en sede penal con posterioridad, lo que probablemente implicaría un golpe mortal no solo a esos delatores a quienes afecte por primera vez, sino que también a la institución misma de la delación compensada. Nada de esto, por cierto, es fácil. Como nos han dicho muchas veces los asesores de las empresas delatoras, y como lo demás hemos experimentado en carne propia, la delación nos obliga a todos quizás a hacer exactamente lo contrario de lo que acostumbramos. Pero esto, que parece ir en principio contra los instintos o inclinaciones naturales de cada una de las partes, debe ser abrazado con total y absoluta convicción, porque es un desafío indispensable que realmente vale la pena. Porque es la única forma de que Chile cuente de una vez por todas y para siempre con una política pública fuerte y efectiva contra la colusión. Una que los cartelistas verdaderamente teman. Una que sancione muy severamente con multas y cárcel a quienes se coludan, como ocurre actualmente. Una cuya autoridad logre detectar de oficio las colusiones, como también ocurre actualmente, pero que al mismo tiempo sea una autoridad muy acogedora, que reduzca al máximo posible las barreras a la entrada de quienes se quieran delatar y les entregue a ellas los máximos resguardos y certezas posibles. Una vez más, estamos frente a la necesidad de un verdadero cambio cultural, que es indispensable, creemos nosotros, para la sostenibilidad no solo económica, sino que también política y social de Chile, nuestro país. Para hablar de estos desafíos para la delación compensada en el contexto de la criminalización, tenemos hoy a dos invitados que verdaderamente son de lujo, y los dejo ahora con ellos. Richard, Scott, thank you very much for being with us today. It's an honor and a pleasure for the Fiscalía Nacional Económica and for our country. Isabel, the floor is all yours. Muchas gracias.
Muchas gracias, Ricardo. Vamos a pasar al inglés ahora para presentar a nuestros invitados de hoy. Today's event is titled Leniency and Criminalization, Lessons from North American Law. And joining us today are the US experts, Richard Powers, who is Deputy Assistant Attorney General for Criminal Prosecution of the Antitrust Division of the US Department of Justice, and Scott Hammond, partner at Gibson, Dunn & Crutcher, and former Deputy Assistant Attorney General for Criminal Enforcement of the Antitrust Division of the US Department of Justice. The objective of this seminar is to review how the criminalization of the cartel conduct, as introduced by the latest reform to the Chilean Competition Act, may impact our leniency program, and to talk about the challenges and opportunities ahead of us in light of the experience of the United States of America, the pioneer and most successful jurisdiction, both in the use of leniency to detect and sanction cartels, as well as in the criminal prosecution of entities and individuals involved in anti-competitive cartel activity. Both of our speakers have vast experience in the implementation and development of the leniency program in the USA, which is why their insights are so useful for us at this point in time. Thank you very much for joining us today, Richard and Scott. Let's begin with the questions. The American leniency policy was created in the 1970s, but it wasn't really successful until it was severely amended in 1993. Scott, could you briefly explain to the audience this policy shift? What made the US DOJ leniency program so successful?
Certainly. Thank you, Isabel, and thank you to the FNE for this invitation to again join the National Competition Day. I had the pleasure of participating in this event in 2009 in person in beautiful Santiago. I'm sorry we all can't be together in person, but I look forward to visiting again with you one day. So you're quite right that the Antitrust Division first had a leniency program that was developed in 1978. That was around for 15 years. And I can tell you it didn't result in the reporting and detection of a single large domestic or international cartel. And the reason was simple, and that is that the US Antitrust Bar did not have confidence in its application. That leniency program reserved discretion with the DOJ prosecutors in terms of whether or not to grant leniency, and its lack of transparency doomed that leniency program, frankly, from the start. So there were three significant, massive, really, precedent-setting changes in 1993 to the leniency program. First was the Antitrust Division for the first time came up with new requirements under a type A leniency program. That is when leniency was reported before an investigation began, that was referred to essentially as automatic leniency. So by eliminating subjectivity and designing the program in such a way to reduce or in fact eliminate prosecutorial discretion to the greatest extent possible, a new program was created. The second major change was for the first time, the program allowed for type B leniency, that is leniency in a situation even after an investigation began. That did not exist prior to 1993. And the third major change was to increase the benefits so that they applied not just to the company, but also to all of the officers, directors, and employees who came forward with the company and cooperated would also receive protection. I can tell you that when this was proposed in 1993, we went up to the Attorney General's office and proposed this novel voluntary disclosure program. And the reaction was, have you lost your mind? The hardest thing in the world for a prosecutor to do is to let go of their prosecutorial discretion. It is important, it's valued higher than anything else. And of course, there's an important place for prosecutorial discretion, but abdicating that discretion in the way that the Antitrust Division's leniency program does was unheard of. What we explained to the Attorney General then was that, look, antitrust crimes are inherently different. They are, I've always believed, the most difficult federal crime there is to prove. It's not the situation that there's going to be witnesses or a smoking gun typically. not going to be like bank robbery where you've got the teller and you've got fingerprints and forensic evidence. These are agreements that have to be proved in the United States to the highest standard or beyond a reasonable doubt, where you have to show a meeting of the minds. To do that, you need an insider. You need someone who is going to testify in front of a jury that they reached an agreement to satisfy that high evidentiary burden. And the other thing is that there are always conspiracies. And so what we assured the Attorney General was the Antitrust Division was going to continue to prosecute and hold individuals and companies accountable. And with antitrust offenses in this volunteer disclosure program, there would always be other companies and individuals that would be implicated in these antitrust conspiracies, which is not always going to be the case. It's not the situation that a leniency program like this would work for other offenses that are always conspiracies. And finally, in terms of what has made it successful, it's not just those rewards. Most importantly, it's creating predictability and transparency with respect to the application of the program. The Antitrust Division's mantra after this program was introduced was, we are going to ensure that companies that come in and self-report conduct will not be worse off for having done so. There was a golden rule that if you come in and you self-report the conduct, we are going to make sure, do everything that we can to make sure that you are successful in achieving leniency. And that means tilting the program. This was also a phrase that was used over and over. We're going to tilt this program to ensure that our leniency applicants are effective when they enter the door, that they're able to obtain leniency. And that's really what was necessary to gain that confidence. If you go back and you look in the 90s, you'll see speech after speech that was given and policy papers that were committing the Antitrust Division to how it would interpret and apply the program. And every one of those speeches was taking issues that were coming up, issues that were raised by defense counsel with respect to uncertainty in the program. And you'll see in every case, the program is being tilted. The eligibility requirements are being interpreted in a way to make it easier for companies to apply. And so again, the last thing I would say is, in terms of what made it successful, was engagement with the antitrust bar. We really viewed the antitrust bar as the clients of the leniency program. And so looking for every opportunity in both public and private forums to listen to the concerns, to take feedback, something I know the FNE has done in the past when it put out its leniency guidelines and its fine guidelines. And I know something that you're considering doing in the future is an important part of gaining that buy-in from the antitrust bar and developing that track record is having that open dialogue.
Thank you, Scott. Richard, could you explain what remains and what has changed from the ideas that inspired 1993's modifications to the program, and what are the reasons behind its success afterwards?
Sure, but first let me say thank you for having me here today. It's an honor to be with all of you to talk about leniency. And, you know, I think I want to step back first and just sort of comment and echo, I think, what was said in the opening remarks and what Scott touched on, which is, and I think the key elements of any successful leniency program, and I think everybody will hear it throughout the discussion today. And, you know, the first one is the threat of severe and significant sanctions. This second is the heightened fear of detection. And the third is transparent and predictable enforcement policies. And it's the last one I know that we're going to spend some time on today in terms of what that means and how you build that trust and the importance of transparency. In terms of, where we are now versus back in 1993, the leniency policy, the leniency program itself has not changed since 1993, the policy. But, some of our practices have evolved over time. Some of the most significant changes have been external ones. For example, the proliferation of leniency programs around the world, the increase in private enforcement, and the changing nature of cartel conduct, which has become increasingly globalized. But one of the reasons for the continued success of the program is our ability, I think, to proactively uncover cartels, which creates this heightened fear of detection that in turn incentivizes companies to self-report. And when it comes to creating an enforcement regime with a credible threat of detection. We've learned that leniency, while it is without question our most important tool, is not a standalone tool. To function properly, it must work side by side with other enforcement tools. So since the early 1990s, the Antitrust Division has steadily expanded its arsenal to include criminal enforcement tools used by other prosecutors in the United States, such as informants, search warrants, subpoenas, consensual monitoring, audio and video recordings, and more recently, undercover agents and wiretaps to investigate cartels. Another key to our success has been our commitment to providing transparency and predictability to leniency applicants. Based on our experience, transparency must include not only explicitly stated criteria and policies, but also a clear explanation for how those policies work in practice. I think we inspire confidence in our program by adhering to our written leniency policy and adhering closely to the approach outlined in our frequently asked questions document, and both of these are available on our website, so publicly available for anyone to see. And it should be noted that our frequently asked questions certainly cannot anticipate every situation. And when we've encountered an unusual set of facts that required us to clarify how we would apply the policy, we've tried to do that. We've also published model conditional leniency letters for prospective applicants to review, and we update those whenever we make changes. And we drafted all of these materials in simple, non-technical language and posted them on the website, as I mentioned before, to ensure accessibility not just to antitrust specialists, but to the business community as well. At the end of the day, for leniency to work, both the applicant and the enforcer alike must honor their commitments in order to reap the significant benefits of the leniency bargain. And to ensure the division continues to receive the benefits of the leniency bargain, we have recently focused on improving the quality of cooperation received by applicants and their employees, because we must be able to translate leniency applicant self-reporting and cooperation into effective, efficient investigations. But we also recognize that leniency does not operate in a vacuum. And as the cartel landscape in the United States and around the world continues to evolve, we as enforcers must stay vigilant to external factors that may affect the leniency structures. So as I started off saying, the core of the policy, the program is the same as it was in 1993. But our practices have evolved over time, and when that has happened, we've done our best to try to talk about it publicly so we can increase the predictability and transparency and maintain that.
Thank you very much. As you just mentioned, Richard, and as the Antitrust Division has stated through speeches given by both of you, one of the three major cornerstones for a successful leniency program is to have severe sanctions. Chile has recently criminalized cartels, and the fixed maximum caps for fines was removed. How do you think this may affect the incentives to apply for leniency? Scott, would you like to start?
Sure. Well, the adoption of criminal sanctions for cartel activity can either be the single greatest incentive for self-reporting or the single greatest disincentive. So it's going to be one or the other, and it depends on the extent to which, first of all, that there is a perception by the bar and the business community that those criminal sanctions are going to be deployed. But most importantly, secondly, the question is are the criminal prosecutors going to embrace the leniency program, be bound by the leniency program? And so when it comes in a jurisdiction where there are both regulatory and criminal sanctions, can a leniency applicant have confidence that the company and the company's employees will avoid both regulatory and criminal sanctions? If that's the case, then it's the single greatest incentive. And if that's not the case, it becomes a liability to the Competition Authority's leniency program. I have over the years been following the developments of the FNE. I do remember a time when you had criminal prosecutors in Colombia relying on, I think it was a 19th century consumer protection law to criminally prosecute leniency applicants, wreaking havoc on your leniency program. I'm aware, really, what I thought of what was a masterful executed plan in introducing criminal sanctions in Chile, which I give the FNE very high marks for. You developed a new criminal law, and you made certain that that would be the antitrust law, that would be criminal antitrust law that would be used going forward. You included, as I understand it, statutory provisions that would ensure that the companies who are the first in would not be subject to criminal prosecution, nor would their individuals. And you put that in the statute, which doesn't exist, I can tell you, in most jurisdictions that have criminal sanctions. And so there you've been able to, I would say, rein in prosecutors that way. And I also understand that criminal prosecutions also require referrals from the FNE. Those are safeguards and guardrails that have been put in place that frankly don't exist in many jurisdictions where they've introduced criminal sanctions and they're having trouble. Probably I believe the most recent example of that is in Peru, where they've now just recently adopted a criminal antitrust law that was actually done over the objection of the Indicopy, and it was done with no coordination with respect to Indicopy's leniency program. And unfortunately for Indicopy, is a major setback for them with their leniency program. But ultimately, the proof is, we say here, the proof is in the pudding. And the next step is, I think you've done everything right when it comes to the way you have created legislation that provides that protection. What you need now are criminal prosecutions, which number one will show that those laws are on the books. They're not just on the books, they're going to be utilized. And two, folks need to see what happens to the folks who self-reported conduct, and be able to see a clear distinction between how they were treated and folks that failed to cooperate and lost the race, what happened to them.
That's the plan. Richard, would you like to give us your views on this?
Sure. So, I think what we've seen in the US is that criminal sanctions, particularly individual imprisonment, have a significant impact on the incentives to apply for leniency. And it's worth probably emphasizing here that only one company per conspiracy can qualify for leniency in the United States. So, when I refer to leniency, I'm talking about the immunity applicant, the initial applicant. A company that is, a second in the door, even if by only a matter of days or hours, and that certainly happens, the company misses, getting the marker by a matter of hours, is not eligible for leniency. And it could be the difference between a complete pass and all the benefits that come from being the leniency recipient in our program versus fines in the hundreds of millions of dollars, single damages versus treble damages in the private litigation. And I think most significantly, immunity for the executive's employees versus the risk and likely prison time. As I said, we've long held the view that individual liability and criminal sanctions, including prison incentives, are the most severe and significant sanctions available for cartel activity. The division has prosecuted and jailed executives at the highest levels of their companies after their employees missed leniency by those days or hours. And just to give an example, here in the United States, recently in this past, I think June, the former CEO of a major US corporation was sentenced to 40 months in prison for his role in a long-running price fixing conspiracy. But the punishment certainly cannot stop at the individuals who commit the crimes. Cartel sanctions must also be sufficiently severe and significant for the corporations that benefit from the illegal conduct of their employees. And our experience has shown us that the prospect of such fines is a major incentive to seek leniency. And so I would expect you to see a similar trend here in Chile as companies and individuals realize that there are serious consequences to engaging in cartel conduct. So, I think it's the other side of the leniency coin, right? I mean, people can understand what the benefits are, but they must be fully apprised of what the risks are for failing to seek and obtain those benefits.
Thank you. Richard, following on to that question, what lessons do you believe can be useful for a jurisdiction that has recently criminalized cartels?
So, looking back, I think one lesson is simply that our approach to criminal cartel enforcement in the US, it works. And over the last 25, however many years, it's worked well. But I can tell you it has not always been easy and continues not to be easy. Implementing an effective criminal regime and developing a successful leniency program are not things that happen overnight. It takes time for an agency to build up its enforcement program. And along the way, there will be skepticism, growing pains, and challenges as new laws are adopted and new policies are implemented. And I think Scott touched on this earlier, but for example, when the leniency program was created, the concept of formalized immunity program was unique in US law enforcement, and no such voluntary disclosure program existed at the time in the US Department of Justice. And we certainly faced skepticism, not only from the private bar, but from our own prosecutors at the Antitrust Division, who had serious reservations about the lack of discretion that is core to the policy. And it took time and a lot of hard work by folks like Scott and others who came before me to get our leniency program to where it is today. And despite initial skepticism, what we have seen over time is that the leniency program is one of the most valuable tools to combat sophisticated antitrust cartels that may otherwise go undetected or unpunished. Another example is the implementation of criminal sanctions. Today, we regularly obtain significant and meaningful corporate fines and penalties in prison terms, like the one I mentioned earlier, for executives. But that was not always the case. The division has worked tirelessly over several decades to convince judges, policymakers, the business community, and the public about the importance of effective sanctions for punishing and deterring cartels. So, anytime there is a major change like criminalization, there will be challenges, but based on the division's experience, we think that criminalization is absolutely a step in the right direction.
Thank you. Scott, is there anything you'd like to add? Any other lessons we could learn from?
So actually, the Antitrust Division has an advantage over every other jurisdiction where there's criminalization is that the Antitrust Division is both the competition authority and the criminal prosecutor. So when the Antitrust Division decides to grant leniency, it doesn't have to go ask a prosecutor to do the same thing with respect to criminal prosecution. So it is both the criminal prosecutor and the antitrust authority. So in terms of looking at experience, I'd encourage you to look to countries like Canada and Brazil and Australia and other jurisdictions that have where the competition authority is separate from the prosecutors. But in that same vein, in terms of what I've observed, two observations. One is that, look, the FNE has to wrap its arms around the criminal prosecutors. You have to bring them in. They need to embrace the leniency program, and they need to do that both, and they need to do that very publicly. I would encourage the FNE next year at this event to have a criminal prosecutor in Chile to participate in the event, and hopefully embrace the leniency program and provide confidence to the Chilean bar that there is a real commitment to seeing that it's successful. I would encourage the FNE to bring along the criminal prosecutors to events like at the OECD or the ICN, to introduce them to criminal prosecutors in Brazil, to make them feel like they're a part of this, to educate them and bring them along and make them partners in this fight against cartels. Because that doesn't happen in a lot of jurisdictions. In a lot of jurisdictions, the competition authorities are protecting their own turf. There's very little communication and dialogue, and you don't have that buy-in. The other thing I'll mention is, one of the last things that Richard mentioned was the education of judges. That did take, for the Antitrust Division, there was a time, particularly in the 80s, where Antitrust Division was bringing cases, obtaining convictions at trial and the defendants were getting incredibly light sentences. There were jail sentences on the books, but nobody ever went to jail. You're going to have that education process as well, but frankly, you and every other jurisdiction that has where cartel offenses are treated as both regulatory and criminal sanctions, you have a bit of a bigger problem, and that is a little bit of a quasi-crime, because if the conduct can be treated as both regulatory and criminal, it's just a matter of discretion in terms of which offenses are serious enough to warrant criminal prosecution, then it's quite possible that the judges won't view that conduct as a crime in the sense that other conduct is always a crime. And so in that way, I would encourage the FNE to really try to develop clear standards that they can articulate, that the criminal prosecutors will follow and are part of developing, so it becomes much more clear, not just to the Chilean antitrust bar and the business community, but also to judges, that there is clear standards that are used in determining which conduct will be subject to criminal prosecution and which conduct is only going to be subject to FNE sanctions.
Thank you very much. Our fourth question. In our experience, leniency is usually counterintuitive. Attorneys have to turn their clients in and voluntarily give inculpatory evidence to the authorities, and prosecutors have to transfer its investigatory powers to defense attorneys and resign to sanctions. Could you please tell us how you manage this in practice? Richard, in your case, how does the DOJ, how has it developed an internal culture to partner with leniency applicants?
Yeah, so, as I mentioned earlier, trust on both sides of the table, so to speak, is key for a leniency program to succeed. And trust starts with transparency and flows through to how we adhere to our policies, right? So transparency and predictable application of those policies. I think, stepping back from that, I think there's one probably slight clarification that's warranted. And we don't, in the U.S., we don't transfer our investigative powers to leniency counsel. Counsel and their clients understand the cooperation requirements and benefits of our leniency program, but they must make their own independent decisions about taking on the former to obtain the latter. But at the end of the day, each side is making their own decisions during the process, which is why, again, coming back to it, transparency and predictability is so critical. And as I mentioned earlier, the antitrust division is transparent about how our leniency program works and are consistent in our practices. From the initial marker request to the final leniency letter, the antitrust division's consistent approach across offices is to adhere to the publicly available rules laid out in our leniency policy. And the division's prosecutors recognize that no one applicant is more important than the integrity of the program, and a prospective leniency applicant must be able to predict with a high degree of confidence its obligations and the outcome following its leniency application. We also take concerns raised by the defense bar seriously and look for ways to improve and evolve our practices. So, for example, over the last few years, members of the defense bar and business community have raised concerns about the rising costs of cooperating in multi-jurisdictional investigations. In response to those concerns, over the last year, we examined our investigative practices and subsequently developed internal best practices at the division for our staff to apply when working with other competition agencies. We also led an effort within the ICN cartel working group to examine this problem and worked with a team of enforcers from around the world, including our colleagues here at the FNE, to draft guidance on cross-border cooperation, which was published in June. We want to do everything in our power to ensure the continued healthy functioning of our leniency program here in the U.S. And I think we have demonstrated that commitment in the nearly 3 decades of the existence of our leniency program. Finally, in terms of our internal culture of engaging with leniency applicants, I'd say that it's no different than any other aspect of our job as federal prosecutors. We faithfully adhere to key aspects of the program that have been discussed here today while engaging with Leniency Council in an open and transparent manner. But as I start off by saying, we must also remember that both the division and the leniency applicant are making independent decisions throughout the process and are acting accordingly. But as I said, and we'll keep emphasizing, that the trust is important, and the way we kind of build and maintain that trust, and I think you all will find the same to be true, is by having the clear policies and practices and adhering to them as best you can.
Thank you very much. Scott, could you tell us how different the role of the defense attorney is when your client is a leniency applicant compared to your regular role defending a client?
Well, look, I remember we tried to do this. I spent 25 years at the Department of Justice. I had not spent any time in private practice until leaving the Antitrust Division in 2014. But I did try to imagine myself in a boardroom, sharing with the board of directors that we had uncovered evidence of wrongdoing, and that we were recommending that the company self-report that conduct to the Antitrust Division. And then thinking about the first hand that would go up and say, I'm sorry, I thought the Antitrust Division doesn't know about this conduct yet. No, they don't know it. We think that it's undetected. And then having to explain to the board why it is that we would go into the Antitrust Division and tell them about criminal conduct that they don't know anything about and may never detect. And in that moment, the Antitrust Division has to be able to provide the lawyer whose professional reputation is hanging in the balance here in terms of telling a client to go in and self-report conduct that the Antitrust Division doesn't know about and could subject the company and its executives to criminal sanctions. It's a leap of faith. And so what is so critical, and Richard did cover this very expertly in terms of demonstrating that the Antitrust Division's keen awareness of this, is things need to go as they're supposed to go. The prosecutor has to know what to expect, has to be able to tell the client, this is how it's going to work. And at the end of the day, the government is going to keep its end of the bargain, because believe me, everything that's happening, as soon as the Antitrust Division, once you walk in the door and you tell them about something they don't know about, or you share information that they don't know about, or in some cases you bring information from outside of the United States, documents into the United States, witnesses into the United States in international cases, there's no turning back. And so it's just so critical in that situation. It's just so different in terms of the confidence that you're literally vouching for the credibility of the prosecutors to your own client. I will just make in a way in which the Antitrust Division and the defense bar in a leniency situation work together that's a little different in the US than in other jurisdictions, relates to the marker system. I have the greatest respect for the European Commission's leniency program, and it's one that has been applied consistently and with integrity for decades. But there's one thing they do, one thing that's different about their application and what is otherwise great convergence between the two programs is the way they apply their marker system. They allow markers, but they're for a much shorter finite period of time. They give you 30 days. You might get another 30 days if you're lucky. But at that point in time, leniency is either going to be granted or denied, and the company's fate is going to be determined much more quickly. The Antitrust Division's leniency program, and this was an evolution in the program, the markers are open for a longer period of time. And what the Antitrust Division, I'll just speak for when I was involved in administering it, we tried to have the standard for obtaining a marker really as low as it could be. We wanted companies to come in when they had the first whiff of potential wrongdoing, not at the end of the internal investigation, not after they had gone and interviewed everybody and potentially risked exposing the existence of the investigation, but at the very inception of the investigation to come in quickly. Again, another leap of faith. And then, so it's a low standard to obtain the marker, but then a high standard of admitting to wrongdoing in order to obtain conditional leniency. But in that time period, the Antitrust Division has historically granted broad markers. Maybe the markers get narrowed by the time that the leniency is granted, so that the protection is coextensive with the confession that is made. But they protect leniency applicants in this marker stage quite often with a much broader marker, so that the leniency applicant is not exposed to potentially being tagged back by another company that could learn of the investigation. And while the leniency applicant is over here investigating the conduct and providing real-time cooperation, it's not exposed to being tagged back by another company for conduct over here that it hasn't quite discovered yet. And working the Antitrust Division, of course, has an interest in seeing that leniency applicants aren't tagged back, and so often will provide those initial broad markers to ensure that leniency applicants are not exposed, and then to help the leniency applicant along the way. I mean, in many ways, when you join the leniency program, Richard talked about people being on two sides of the table. Antitrust Division has a job to do, and of course, those representing leniency applicants do too. But you really do end up working hand in hand with the government to try to assist them in their investigation, and also to ensure that your client is completely covered for the broadest possible protection and is not left exposed to any criminal prosecution.
Thank you. The leniency program in the US requires applicants to report the wrongdoing with candor and completeness and provide full, continuing, and complete cooperation to the division throughout the investigation. Richard, could you tell us what this means and how it works in practice?
Sure. And so I'm actually going to go back to something Scott mentioned, because I think it's a great point, and I want to use that to sort of jump off into answering this one, which is with respect to our marker system. I will tell you it's something that I've talked to counsel before in various contexts, but in emphasizing that, we keep a very low threshold for securing a marker. It's, if you look in the FAQs, it's there because what we want, and I think what makes this process work, is as soon as there is that whiff of wrongdoing, we want that race in, and then you get the marker. And what I think you will find, and what counsel would find working with us, it's certainly been my experience, is that we will, once a company has that marker, once an applicant has that marker, we will work with them along the way to enable them to really fully develop the facts and kind of assess, what should the scope of the marker be, and kind of the direction of, where the process is going to go. And I think it kind of leads to the question you have, which is, what is, when we talk about our cooperation, our expectation is that a leniency applicant will provide truthful, full, continuing, and complete cooperation. And cooperation includes conducting a timely and thorough internal investigation at the company, providing detailed proffers of the reported conduct, producing documents no matter where they are located, and making the using best efforts to make cooperative witnesses available for interviews. We certainly recognize that in the early days of large international cartel investigations, the company and its counsel may need time to fully ramp up its investigation. And as I said before, we will work with counsel to set realistic timelines for initial attorney proffers and document productions. But our experience over the years has taught us that speed is crucial at the early stages of an investigation. And our expectation is that leniency applicants need to move quickly and expeditiously to provide early cooperation, which could allow us to develop the facts quickly, and in some cases by using covert techniques to expose more information about the nature and extent of the conspiracy. When it comes to key employees of the leniency applicants, proffers from their counsel are no longer sufficient to ensure coverage under the company's conditional leniency letter. And while we may ask counsel to provide these helpful proffers in advance of our own interviews, we expect to meet with these key employees to confirm that they are committed to meeting their leniency obligations. In essence, we are assessing whether they are being candid and fully forthcoming and telling us all that they know. And we may also require covered employees to assist with the proactive investigative techniques where appropriate. And as I said before, those are important parts of our investigation and important tools in our arsenal. So when we talk about providing full, continuing, complete cooperation, these are the sorts of things we're talking about.
Thank you. Scott, considering your experience as a defense attorney, how difficult is it for you to secure cooperation from your client, particularly from key employees and executives?
Well, in the leniency situation, if it's available and not just the company, but the individuals stand to benefit, it's actually a situation where the interests of the company and the individuals are perfectly aligned. It's completely unique to antitrust investigations. Outside of antitrust, if, for example, I'm representing a company in a situation that involves anti-corruption, what we refer to as the FCPA investigations here. In that situation, the voluntary disclosure program administered by the DOJ is much different. It's not as transparent. It's not as transparent, but importantly, it also doesn't cover individuals. So the message from the Department of Justice to the defense bar there is, if you come in and self-report corruption, the company will be better off. But what will be expected from the company is that it will provide cooperation that allows the Department of Justice to prosecute the company's own employees. So the conversation that you can have in an antitrust investigation, well, actually, I'll just start. If this was an FCPA investigation, if I was being very, you wouldn't say this at the start of an interview, but if you were sitting down with an employee, you would say, my name is Scott Hammond, I represent the company. I have some questions for you today. It's very important that you be truthful and candid, because everything that you share with me, I intend to put hand over to the criminal division with a nice bow on it, so that my client, the company, can get a better deal. I wouldn't, of course, say that, but that's what's going on in that situation. You're trying to learn information from the employee, information that could benefit the company, not the employee. And so it's obviously a very precarious situation for the individual. They in many cases want to cooperate, but they are in a position where their cooperation could be effectively used against them. That's not the situation with leniency. My name is Scott Hammond, I represent the company, I don't represent you, but we are at a very important crossroads. The Antitrust Division has a voluntary disclosure program. That disclosure program has enormous benefits for the company. It means that the company can avoid criminal prosecution and sanctions, but the benefits for you are even more significant. If you've been involved in wrongdoing, you can go to jail. But if you tell me about what you're involved in, and you tell me now, in a time when we can go in together and seek leniency, the company will wrap its arms around you. We will go in together, and we both stand to benefit from that. And so actually in that situation, even though I'm representing the company, the interests of the company and the individuals are aligned. It's what actually, it's what makes part of what makes the leniency program successful is that maybe it was even unintended. The Antitrust Division wanted to create a situation where there were greater benefits, but I don't think we appreciate quite at the time that we are also at the same time giving company counsel the tools to conduct effective internal investigations, where it would be in a position to obtain more information from its employees, who would have every interest to be candid and cooperative, and allow the company then to come forward with that information and help the government in its investigations.
Thank you. Referring to corporate plea agreements, Richard said in a recent speech that full cooperation also requires that cooperating companies and individuals report all pertinent facts, whether favorable or unfavorable, and that the division will ensure that the information provided is indeed complete and does not seek to minimize exaggerate, or otherwise misrepresent the behavior or role of any individual or group of individuals. Richard, in the case of leniency, how do you deal with applicants that don't fully cooperate? And what are the possible consequences for a corporation that doesn't meet this standard?
Sure. So I probably will talk about it in both contexts, both in the what I was referring to in that speech with the corporate, the pleas, as well as in leniency. Although I think our expectations of cooperation are, I think, similar across the board. As I mentioned earlier, we have the first in gets the leniency, the immunity, and everybody else, sort of, it's a race to provide valuable cooperation. In the US, the company and individual co-conspirators can enter into plea agreements and cooperate with our investigations in order to receive a reduction in fine and in jail sentences. And in the speech you mentioned, I was discussing the standards of cooperation, with companies that haven't run the race for leniency, but are nonetheless seeking benefits for cooperation. Like leniency, the benefits of a plea agreement are not a free ride. In order to attain the benefits of cooperation, companies and individuals must meaningfully assist the division's investigation through truthful, thorough, and timely cooperation. And as I said in that speech, truthful cooperation means being candid and providing complete information, even when the facts may be unfavorable, in whatever context that may be in. And for those who misrepresent or shade the evidence or omit relevant facts when they're purportedly cooperating with us, this can potentially foreclose a company or an individual from receiving cooperation credit or a reduced fine. So for example, and I think I cited this in the speech, in at least one instance during my tenure at the department in this role, we reduced the cooperation credit for a cooperating company's criminal fine by 50% because of deliberate omissions in the information that was proffered to us. This was not something that we took lightly, and we provided an opportunity to be heard for the company by the division leadership before making a final decision. But just as there is a significant credit for full and truthful cooperation, there are consequences for providing cooperation that falls short of candor. And for leniency applicants, as it states in our model conditional leniency letter, if applicants do not provide the cooperation required, the division may revoke the applicant's conditional acceptance into the leniency program. And I think, I would say, fortunately, with only one exception, the Stolt-Nielsen case, the division has not encountered a situation that resulted in us revoking an applicant's conditional leniency.
That's good. Scott, you said in a speech that companies are aware of the DOJ's success in uncovering related offenses through the cartel profiling technique, and so they often turn the company upside down to try to discover any additional wrongdoing before we do. Amnesty Plus would be the carrot for this, but what is the stick in this case? In other words, what consequences can a company face if they knowingly fail to report a violation in a related market?
Yeah, that was a quote from a speech that I gave when I was at the Antitrust Division, and it was referring to the Antitrust Division's track record at that time, which was that over 50% of the time when the Antitrust Division opened an investigation, it would lead to the detection of an additional unrelated conspiracy, antitrust conspiracy. Deploy cartel profiling techniques, and by that I mean techniques that, recognizing that if you had 4 or 5 companies that were involved in cartel activity, trying to determine whether or not 1 or 2 or more of those companies also compete in other markets, looking at the investigations across the Antitrust Division or past investigations to see if any of the companies involved in the current investigation compete against another company who is being investigated or may have been involved in wrongdoing. to see if there's wrongdoing there, looking at the individuals who are involved in the conduct. I mean, if you've got a 55-year-old senior vice president who's been involved in the cartel for the last 2 years, the antitrust division prosecutors can sometimes be a little cynical. They don't think that they don't assume that one day on this individual's 53rd birthday, they decided today I'm going to join a cartel for the first time. So they they're suspicious. They think maybe this individual's been involved in other cartel, and it's like, I wonder who mentored this person? How did this person come to the point where they were involved in leading a cartel? And who else is this person mentored? And these are all the kind of cartel profiling techniques that they're going to be following. And the antitrust division prosecutors, I've seen this happen when I was there. They would bring in defense counsel and they would say, these are the things that we're going to be doing. And so you may want to do them first. You may want to be conducting an investigation and asking these same questions and trying to dig up if there is anything out there to find it first. Because if you do, even if if this is a company who has already lost the race for leniency, you can qualify for Amnesty Plus, which means that you can get leniency for the undetected conduct, which we're going to be looking for. You can get leniency, and then you can, of course, the plus is you can obtain an additional discount on the conduct that was already under investigation that you failed to self-report. And the flip side of that coin, and of course there always has to be another side of the coin, is what the antitrust developed a program called Penalty Plus. And that message simply was, if you're involved in wrongdoing and you failed to discover it, and it turns out that you've got not just one problem, but a second problem as well, and the antitrust division believes that you've discovered the conduct and failed to report it, then it is going to seek a fine at the very top or above the top of the sentencing guidelines. But and in addition to that, the antitrust division in that situation will also seek probation for the company, and as a condition of probation, may also seek to have the court impose a corporate monitor, which no company wants to have, be living under a corporate monitor for a number of years, overseeing the company's future compliance. The most notable example of the implementation of this Penalty Plus program was against Bridgestone, who was found to have involved in 2 separate conspiracies. The second conspiracy was one that the antitrust division came to believe that the company detected and decided to try to hunker down in hopes that the antitrust division would not detect it. And when the antitrust division did, it imposed a very heavy fine, and part of that included an additional $100 million for its failure to report the second conspiracy when it had a chance. I should also add, that's not the only consequence. There were a number of individuals who were prosecuted in that second conspiracy. And of course, if the company had come forward when it detected the conduct, it would have avoided not just that heavy criminal fine, but its individuals could have avoided prosecution.
Thank you very much. We're going on to our last question that we have time for today. Nowadays, it's impossible to talk about leniency and not touch upon follow-on damages claims and how they may affect the incentives to apply for leniency. Richard, what's the DOJ's view on this?
So yeah, it's certainly true that the United States has a robust tradition of private antitrust actions, which allow victims of antitrust violations to recover treble damages. Private litigation was intended to supplement government enforcement, empowering victims to act as private attorneys general. We respect the role that private civil litigation plays in our system. This has been a deterrent to corporate leniency applicants whose civil liability might even be more significant than their criminal fine amount. And so to address that problem, our Congress passed a law in 2004 called the Antitrust Criminal Penalty Enhancement and Reform Act, which is a mouthful, so we refer to it as ACPARA for short. And under ACPARA, a successful leniency applicant under the division's corporate leniency policy has its exposure to civil damages limited to its pro rata share of the total damages before trebling, provided that the company cooperates with the plaintiffs in the civil actions. AgPara was extremely successful in creating the proper incentive structure for our leniency program to flourish. And in fact, just this past October, the President of the United States signed into law a bill making AgPara a permanent fixture of our enforcement regime. But lately, we've encountered additional issues with private civil actions that have once again caused us to re-examine our policies and practices. We are seeing that private plaintiffs are filing cases as soon as they learn of a criminal investigation. And if these civil complaints are filed too early, they can unduly complicate our criminal investigation. So for example, document requests, especially those that seek the production of everything that was produced to the government in its investigation, and the deposition of potential government witnesses can have a significant negative impact on our cases. These requests also add another layer of competing demands on a leniency applicant or another cooperating company. Of course, restitution to the victims is an important component and part of our leniency program and a priority in any of our criminal investigations. But the division has concerns that the burdensome competing demands in civil cases are affecting our leniency applicants' ability to provide robust cooperation in criminal investigations. We are also concerned that the prospect of fighting civil litigation and complying with civil discovery demands may, in some instances, act as a disincentive to seeking leniency. And to remedy part of this, we have been taking an aggressive position on intervening and seeking to stay discovery in civil cases while our criminal investigations are ongoing. Our experience with AgPara demonstrates that it's important for us to think about the big picture and consider the full scope of liability that a potential leniency applicant faces and the U.S. could face as it decides in making that decision on whether or not to self-report. And if we can reduce some of those external costs, I think leniency will be even more effective.
Thank you very much. Scott, could you tell us what your perspective from the defense bar is on this issue?
Well, I was actually in the antitrust division when AgPara was passed. We recognized, and Congress recognized, that the threat of civil damage exposure was a significant deterrent. And so this legislation actually was passed at the same time that maximum penalties for individuals and companies went up. That was the stick. And simultaneously, in the same legislation, AgPara was created to encourage folks to come forward, self-report, and in doing so would have their civil damage exposure limited to actual damages, so reduced from triple damages to single damages, and the elimination of joint several liability. And initially, we did see a bump in applications. There was actually a consensus across the defense bar and the plaintiff bar and the business community. This was a good thing, and people thought that it had a lot of promise. Unfortunately, it's become clear that it's not working as intended, and the benefits that I just described are, frankly, in my opinion, illusory. Unfortunately, that's because while the antitrust division has an institutional interest in protecting the integrity of the leniency program and applying it in such a way to ensure that the incentive for self-reporting always are paramount, and that's what Richard and his team do. The private plaintiffs or a plaintiff counsel doesn't have that same institutional drive. They're just representing a single client, trying to get the best result for their client, and so they have figured out that they can game AgPara to their advantage. The whole idea was with AgPara is to make sure that the leniency applicant gets a better deal than companies who didn't come forward, and that they were able to obtain peace, finality, and certainty much earlier in the process, since they're admitting to their involvement and their liability is limited. but the plaintiffs have figured out that they can take insist on the cooperation without offering a resolution, and often seek to keep the leniency applicant in the case. So not only is the company not getting a better deal, but they're not able to avoid the costs associated with the litigation either. So unfortunately, this is a real missed opportunity, and it's hurting the leniency program because the calculus has changed. Folks used to think of ACPERA as being a major benefit. They no longer do. And so that cost benefit analysis shifted in that way. I just think it's every jurisdiction with a leniency program needs to address how private damages are, the threat of damages will impact the decision to self-report. As Richard said, I mean, if you're a company, say you're a company who doesn't care about the individuals. In fact, you're a company who thinks the individuals should be prosecuted and get what's coming to them because they violated the company's code of conduct. There are plenty of companies who have zero tolerance policies who don't care about their about the company. Excuse me, don't care about the employees, but they certainly care about the company's bottom line. Those companies are doing a cost-benefit analysis, and this threat of private damage exposure, as Richard said, those numbers are much higher in most cases than whatever fine they're avoiding. I would just, the last point I'll make is really to the folks at the FNE is to always remember that the decision whether to self-report, it's such a challenge for counsel to secure the confidence of their clients, to self-report conduct and expose the company in that way. And this decision and the balance between whether to report or not report, it's very fragile and can never be taken for granted. And when the incentives begin to shift, and this is, referring back to with ACPERA, no longer being as effective as it was before, that fragile balance can really be upset. And, you can have situations where companies, counsel will advise clients differently than they might have before.
Thank you very much. Unfortunately, that's all we have time for today. We would like to thank both Richard and Scott for taking the time to be part of this year's Día de la Competencia. I'm sure all of us here have a lot to learn about the experience of the United States in implementing such a successful leniency policy over the years.
Thank you.
No, thank you very much for having us.
Gracias Isabel, gracias Richard, gracias Scott. Lamentablemente y por problemas de tiempo no vamos a poder dar paso a algunas preguntas que teníamos del público. Queremos agradecer a todos los que nos acompañaron hoy día en esta versión 17ª del Día de la Competencia, primera versión virtual, tal vez no la última, y esperamos que nos acompañen en las futuras acciones de promoción que vamos a realizar, y queremos desearle a todos una feliz fiesta. Happy holidays for you too, Richard and Scott.
Thank you.
Muchas gracias a todos. Nos vemos.
Thank you. You too.